My name is Meshach Masibo, and welcome to episode 1 of the Data Protectors podcast. The objective of this podcast series is to offer guidance to small and medium-sized organizations and enterprises on how to become compliant with Kenyan data protection law. Today, specifically, we are coming to you with an exciting episode that we've been developing to help small and medium-sized businesses and organizations, as earlier mentioned, to understand the basic principles of data protection and to integrate them into their day-to-day operations. But before that, let's have a look at the partners behind this podcast. Have you heard of the African Union, European Union Digital for Development, or D4D Hub? In a nutshell, it is a project that aims to increase cooperation in the digital field between Europe and Africa, and it is implemented by 8 organizations including GIZ, the German Development Agency. Did you know that our Data Privacy and Protection Act in Kenya was inspired by the European one, which is called the GDPR? Therefore, data protection is a very interesting field for Africa and Europe to collaborate on, which is how this podcast came to life. We'll share more information about the EU D4D Hub project and the partners as we go along. But let's start hearing from our guests. For this episode, I'm excited to introduce our guest moderator Megan Kathure and our 2 speakers, Mercy Mutindi and Liesa Borghaert. They'll serve as our guides for this episode.
Welcome to the show. I'm Megan Kathure. I work as a tech policy analyst and researcher on data governance, technology, and cybersecurity. As Meshach has mentioned, in this episode, we will be talking about data protection principles for small and medium-sized businesses. To help us break this down, we have Mercy Mutindi, who is a certified information privacy manager in Kenya, and Liesa Borghaert, who is an attorney in data protection law, IT, and IP working for the law firm Timelex in Brussels. Before we dive into the relevance of data protection principles, let's give you all a quick overview of the small businesses and organizations that this podcast targets. They can be described as enterprises that have 1 to 50 employees and often are resource-starved, meaning they lack the capacity to, among other things, invest in compliance or the capacity to hire skilled data protection officers to guide them through compliance. And remember, whereas SMEs, startups, and small civil society organizations are slightly different in their business models, they all face the similar challenges when it comes to data protection compliance. We hope to have many of you with us as our listeners, as this podcast series will be specifically designed for you. So we begin with you, Mercy. On the 28th of January marks International Data Privacy Day. Why is this significant for Kenya?
It's significant because it provides an annual focus for everybody within the nation, from government, the regulator, private sector, civil society, as well as the international community of stakeholders to educate the public on data protection, discuss the current challenges in the space, as well as inform individuals about their rights, how to exercise them, and discuss the responsibilities of various stakeholders when it comes to personal data. The Data Privacy Day is the one day where most of the world is talking about data protection.
Liesa, what about you? What is the significance of International Data Privacy Day in Europe?
Well, of course, much like in Africa, Data Privacy Day is a very important day in Europe because it puts the spotlight on privacy and data protection. It raises awareness among citizens and promotes best practices among businesses. But in Europe, Data Privacy Day, or as we call it, Data Protection Day, is extra special as it marks the anniversary of the Council of Europe's first legally binding international law in the field of data protection, the so-called Convention 108. So I guess that makes the day extra significant for us as well.
That is interesting. I'll turn to you, Mercy. Why is it important for small businesses and organizations to comply with the Data Protection Act?
First of all, it helps in enhancing consumer trust, and this helps the business with competitive advantage. So, for example, in Kenya, in the fintech sector, studies have been done by SIGAP that show that customers are willing to take loans from providers with slightly higher interest rates than the rest of the market, where these providers protect their privacy. So, we have seen in the recent past in Kenya huge outcry in the media about bad data protection practices in the fintech space. So, compliance is a solid part of gaining and keeping consumer trust that translates into higher competitive advantage as well as higher customer retention for businesses. Now, other benefits also include brand protection as well as enhancing the reputation. Now, You do want as a business to be known for the right things and to be known for good things. So complying also helps in avoiding fines that can go up to 5 million Kenyan shillings per incident in Kenya. But it also helps with enhancing that good reputation, making the SME as well as the CSOs or the small outfits more attractive to investors who have also seen to take data protection compliance as a serious part of due diligence as well as preconditions for funding.
Back to you, Lisa. Europe is relatively more advanced in data protection. How have small businesses and organizations responded to the GDPR, which is the law governing data protection in Europe?
To be honest, I think at first many small businesses and organizations felt like the GDPR was not something they had to comply with, and they left it to bigger organizations. However, once smaller organizations noticed that their customers were becoming more and more aware of their rights under the GDPR and that investors too valued GDPR compliance a lot, they realized that compliance could indeed provide them with a competitive advantage and started working towards compliance as well.
All right, Lisa and Marcy, what do you think then are some lessons Kenyan small businesses and organizations can learn from Europe on how to achieve data protection compliance? Lisa.
In my practice, I've learned that compliance by small businesses and organizations is best achieved by taking a step by step approach. I would advise small organizations to appoint one person as a so called data protection manager, and that this person could get him or herself acquainted with the principles and requirements of Kenyan data protection law, for example, just by listening to this podcast. This way, he or she would already get some understanding of what data protection law is all about and what reflexes one should have in day to day business. And then afterwards, I would encourage this person to work towards compliance on the surface, if I can call it that. By this, I mean that it's important to first focus on putting in place the most crucial documents and procedures, such as, for example, a privacy policy and an internal procedure for handling requests from customers, which are probably the aspects of data protection law businesses will be confronted with most. Once all of that's been put in place, further steps can be taken to really increase the level of compliance to where it should be.
All right. Lisa, from a European perspective and your experience, then what are the challenges that small organizations and businesses have faced in ensuring data protection compliance, and what was the approach towards this in Europe?
The main two challenges that small organizations and businesses faced in Europe were, first of all, the limited resources they had, both financially, but also in terms of times and personnel. And secondly, the difficulty they had in grasping some of the principles and concepts of European data protection law. I believe, especially in the beginning, many organizations did not fully understand what the purpose of a privacy policy was or why they couldn't just copy a privacy policy from another website. Luckily, data protection authorities in Europe have jumped in and have published lots of guidance on their websites that is relevant to SMEs, for example, on the GDPR in the workplace. They have also provided SMEs with template forms and FAQ lists, which I believe the Office of the Kenyan Data Protection Commissioner has done as well.
All right, Lisa and Mercy, it's important for startups, SMEs, and small organizations to understand the data protection principles. Please tell us more about these principles, Lisa.
So, the data protection principles are what I would call the fundamental pillars of data protection law. This means that whenever an organization is processing personal data, be it when collecting personal data or when storing it or adapting it, these core data protection principles need to be respected. There's seven principles, and once you get the hang of these, I assure you, you're already halfway in your data protection compliance. I'll first quickly list them and then we can maybe go over them one by one. So the first principle is the principle of lawfulness, fairness, and transparency. Then, secondly, there's purpose limitation. In third instance, there's data minimization. The fourth principle is accuracy. The fifth is storage limitation. The fifth is integrity and confidentiality. And the sixth is accountability. I'm missing one.
It's okay. please break this down for us. What is the principle of lawfulness, fairness, and transparency? And how is it different from the principle of integrity and confidentiality?
The first principle of lawfulness, fairness, and transparency essentially means that businesses can only process personal data if they have a legal basis for processing these data, and if they process the data in a fair and transparent way. In data protection law, there are several legal bases on which a company can rely to legitimize the processing of personal data. For example, if a web shop sells a book, it will have to send the book to the customer. In order to do so, it will need to process the name and the address of the customer. That entails a processing of personal data. Such processing is, however, lawful because the business in this case could rely on the necessity of the processing for the performance of the contract, which is the sales contract in this case. Um, Other legal bases are, for example, the consent of the person whose data you are processing, or the need to process personal data to comply with the legal obligation. Fairness and transparency, on the other hand, means that the processing should be fair and that you should be transparent about what personal data you are processing, for example, by explaining this in a privacy policy. Your privacy policy should, for example, indicate what personal data you will collect if a person visits your website or hands you their business card, and who you will share this information with. The principle of integrity and confidentiality, on the other hand, means that you can only process personal data if you do it in a way that ensures the security of the data. You have to make sure that the data cannot get lost or destroyed, or that unauthorized persons cannot get access to them. Compliance with these principles can be achieved by implementing passwords, access authentication, access logging, encryption of data, etc.
That is interesting. So, what about the principle of purpose limitation? What is it, and how is it different from the principle of storage limitation?
The principle of purpose limitation is actually very straightforward. It means that personal data should always be collected for a specific purpose and cannot be further processed for a purpose that is incompatible with the original purpose. For example, if you collect the contact details of your employees for payroll administration, you cannot use these data later on for direct marketing to these employees. You could, however, further process these data to reimburse these employees' travel costs, as this can be considered a purpose that is compatible with the original purpose of payroll administration. The principle of storage limitation, on the other hand, merely means that you should not keep personal data in an identifiable form for longer than is necessary for the purposes of which the personal data are processed. For example, the yearly performance reviews you make of your employees will contain personal data about them. These data become outdated and irrelevant after a while, so the storage period of such personal data should be 2 to 3 years at a very maximum.
All right, we're learning a lot today. What about the principle of data minimization? Can you tell us a bit about that?
The principle of data minimization states that you should only process personal data that is adequate, relevant, and limited to what is necessary for the purpose of processing that you have in mind. So, this means essentially that the worst thing you can do as a business is to try and collect all the data you possibly can and then only think for a use of it later on.
So, to close us off, can you tell us about the principle of accuracy and accountability? What are these, and why do they matter for SMEs and small organizations?
Sure. The principle of accuracy means that the personal data you process as an organization should be accurate and should be kept up to date. Organizations should thus rectify or erase inaccurate data without delay. As best practice, organizations should thus, at regular intervals, ask the people whose data they process to review if the personal data is still correct and to rectify it where required. The principle of accountability, on the other hand, is an overarching principle, which means that as an organization, you are responsible for compliance with all the principles we've already mentioned before, and that you should be able to demonstrate compliance with these principles, for example, to your data protection authority. And how do you do this? Your compliance can, for example, be proven by providing regular training to your personnel, by implementing internal data protection guidelines and procedures, etc.
Marcy, anything you'd like to add on data protection principles?
They are the core of data protection and, in essence, summarize most of what the rest of the law is about. Now, and it also just sort of related to the golden rule of do to others what you would like them to do unto you. As a small organization, you are a customer of some business somewhere. It's not that hard to think through how you would like the organizations that are serving you to handle your data. It is the exact same thing that you should do for your customers. Respect their privacy, respect their personal data, and manage it in a way that respects them and is in keeping with the dignity of your customer.
So this question goes to you, Marcy. What are some examples of how small businesses, startups, and small CSOs can integrate the principles of data protection in their daily work?
So, one of the fundamental pillars that can enable small organizations to journey towards compliance is the adoption of privacy by design, or privacy by default in the way they create products. So, for privacy in product creation, should be one of the, if it's online, for example, if it's a tech based product like a system that is being designed, then there should be privacy that is provided for as a setting by default. So, one of the examples, if it's a small business that's maybe building a website or a social media site where either employees are able to interact with each other and serve customers, or they're able to, if in the case of social media, make posts out to the public, then the settings for the post should, at least by default, be either private or limited to their friends, not automatically open to the public. And in the case where the posts are automatically open, to a public audience, then that needs to be clearly indicated and prominently displayed to the user the first time they log in or the first time they're doing a post, so that they are aware. The user needs to be empowered with the different models in which they can restrict access to who can access what information that they have. In the case, for example, where the design is for maybe a human resource information management system, or even a health services records, for example, in hospitals, then when you're designing that system, privacy by design means that, first of all, you build it in such a way that access rights can be designated for each and every user. And for example, when uploading a user to the system, you have to actually assign them some level of access. They don't automatically have access to everything, as if they're a system administrator. So it's one of those things that takes some time to build into the products. That is for electronic products or technology-based products. Now, for the offline world, it is still important, and data protection principles still apply there. For small organizations, if it's a small school or a small organization with, maybe 15 employees or 20 employees that focuses mostly on hard copy data, then it's just the normal common sense things. Classify your information. Payroll data should not be put, at the front desk at the reception, accessible to anybody who walks into the organization. Have cabinets that are marked out for sensitive information or personal data that is sensitive. Keep them under lock and key. Do proper filing. Do proper indexing. Know where what data lies and protect data according to the sensitivity labels. And then also ensure that the personal data, and especially if it's sensitive, is not accessible to everybody. So in the case of a small clinic where they have physical files, it means the filing cabinet where patient records are kept should be in a room, for example, where there's restricted access, where they're able to track who has access to what, when, and why. And not everybody should be able to just walk into that room and open a patient record and see, the different health status items of that particular patient. Now, another key thing was also mentioned by Liesa earlier when she talked about privacy notices. Make sure that, there are some privacy notices that communicate to the customer or the end user what you do with the personal information that you collect about them, how you process it, how long you store it, how they can reach you in case they have issues or queries. And if they are not satisfied, then where do they go to complain? How do they lodge complaints? And what are the resolution timelines for such things? Those are some of the things that would be very useful. Then internally for employees, it is important to do some housekeeping. have some training, as well as some clear standard operating procedures or guidelines that guide them on how to handle different types of personal data that are collected within the organization, with particular and specific attention being paid, obviously, to sensitive data. The more sensitive the information is, the more protection that it needs.
Thank you for giving us such excellent examples, Mercy. So, any final thoughts to both of you?
So for me, just my final thoughts is that data protection compliance is good for society as a whole, and it is good for the customer as their information is kept safe and used appropriately. It is also good for businesses and small organizations, as we have discussed, as part of competitive advantage, earning consumer trust. It is also a reputation enhancer and a funding attractor. So it is very, very good for small organizations and business to find a way to put data protection within their normal ways of working so that they are able to maintain a good reputation. And it also helps them save costs, for example, by avoiding unnecessary storage capacity and expenses, as well as avoiding unnecessary fines.
Liesa?
I think my final thought would be that businesses and organizations should keep in mind that the processing of personal data they perform should always be fair and in line with the expectations of the people whose personal data they're processing. That's what Mercy also mentioned with this golden rule. And I believe the 7 principles we've talked about today can already help organizations in having the right reflexes on what they can and cannot do with personal data.
Well, we have come to the end of our show. Thank you so much for listening. To stay updated on the data protection laws and concerns in Kenya, be sure to follow D4D Hub throughout the coming weeks. Thanks so much to our guest moderator Megan Kature and speakers Mercy Mutindi and Liesa Borghaert. The Data Protectors Podcast is a podcast produced in collaboration between GIZ Kenya and Kicternet as part of the AU-EU D4D Hub project. Follow the AU-EU D4D Hub on social media, and you can find us on Twitter at D4DHubs_AU-EU. You can contact us there as well. If you're listening to us on Anchor, you can also leave us a voice message. Yeah, and don't forget that all the episodes of this series are available on D4D Access. D4D Access is an online platform powered by the AU-EU D4D Hub, which aims to promote exchanges of knowledge and expertise between African and European digital stakeholders. Feel free to visit their website at www.d4daccess.eu. Thank you so much for listening and see you next time.